Welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the basics of property law. We consider four fundamental questions, and today we are talking about the fourth, which is holding interest in property. Our focus is on those times when private property owners may actually have to relinquish their rights to property pursuant to governmental exercises of eminent domain. The key issue in eminent domain cases is usually the term public use, which is discussed in the introductory video about the takings clause and its elements. Perhaps the most famous 2005 Supreme Court case in this arena, which even got a movie, is Kelo versus the City of New London. We cover that case in another video. But I think it's important to discuss two prior Supreme Court cases to show why Kelo really wasn't as big of a sea change as some people suggest. These cases are discussed in Kelo, and they are Berman versus Parker and Hawaii Housing versus Midkiff. So let's start with Berman versus Parker, decided in 1954. It dealt at the time with what was called slum housing in Washington, D.C. Three neighborhoods were particularly concerning to local leaders at the time: Georgetown, Capitol Hill, and Southwest. The first two, as anyone who lives in DC knows, are very expensive parts of the city today. But to understand the Berman case, you have to go back to 1945 when Congress passed the DC Redevelopment Act. This granted the DC Redevelopment Land Agency power to use eminent domain to redevelop blighted areas. Think back to this middle third of the 20th century. There was an unusual faith in government, in part because the Great Depression was thought to be a real defeat of markets. A lot of voices, from architects to planners to urbanists, advocated muscular government involvement in renewal of cities. So that's the context in which this case is decided. After a few years, the agency, which had been created, made a plan to develop a part of DC, Southwest, where 65% of the buildings were said to be beyond repair. At the time, the neighborhood was poor and predominantly Black. The owners of a department store in the designated area brought suit. They essentially argued that the store itself was not blighted, and so its redevelopment to create a, quote, better balanced, more attractive community, end quote, was not a public use. The Supreme Court disagreed. It upheld the use of eminent domain unanimously. It deferred to the agency's planning and surveys and said that the entire redevelopment plan was a public purpose and that the use of eminent domain over individual parcels was necessary for the plan's functioning as a whole. Ultimately, as a result of the decision, 20,000 people were displaced, although the court only counts about 5,000. As an aside, note that this case has often been used by those who want to argue that its aesthetic regulation is a public use. Justice Douglas wrote in the case, quote, "It is within the power of the legislature to determine that the community should be beautiful as well as healthy, spacious as well as clean, well balanced as well as carefully patrolled," end quote. This view that the public use can include physical, aesthetic, and monetary benefits has therefore been an important case justifying architectural review and historic preservation laws. If you want to learn more about those laws, feel free to check out my books on land use and historic preservation law. You can find links to those on my website. So with that, we move to the second case. 30 years later, in 1984, the court again issued a landmark eminent domain decision in Hawaii Housing versus Midkiff. At the time, the state and federal governments owned about half of the land in Hawaii, and most of the rest belonged to 72 private landowners. There are a lot of things wrong with this kind of concentrated land ownership. It skewed the state's residential market and inflated land prices. Even if landowners wanted to sell, they couldn't. They had so much land that to do so would incur huge capital gains taxes. So the Hawaii legislature had a solution. They adopted a statute that employed eminent domain to take fee title from lessors and transfer it to lessees. Mechanically, the way it worked was that they first held a hearing to determine if eminent domain in that case would be supported by a public purpose. Then the legislature condemned land or negotiated with the owner. This case, the Midkiff case, came about when negotiations with the property owner, Midkiff, failed and the state condemned his property. The condemnation was eminent domain, so to be valid, it had to comply with the takings clause. Once again, the court unanimously upheld the statute and the exercise of eminent domain, because in their view, the public use was rationally related to the purpose of correcting for a land oligopoly. The decision was written by Sandra Day O'Connor. The court was very deferential to legislative judgment in that it viewed the public use requirement as coterminous with the sovereign powers of the legislature. Keep that in mind. And when we consider Kelo, we'll see Justice O'Connor's views in that case. In both Berman and Midkiff, the court willingly supported the economic development justification for the use of eminent domain. I encourage you to think about whether the later takings case, Kelo, again covered in another video, was really so different from these cases and their findings about a public use. So I will leave it there. I'd love to hear from you, whether on Twitter or through my website, where you can sign up to my mailing list. See you next time.